matter, we would urge the court not to consider any of the facts about the underlying case, including the exhibit that's now been entered of Ms. Wooten's testimony at trial. Under the rule of optional completeness, I think we get to put the entire trial and all of the exhibits into the record for this board to look at if you're going to go there, which we do not think that you all should do. Okay, I'll give my closing. Members of the board, you've heard all day about how corrupt Collin County is, about how terrible it is, about how this was just a political prosecution. But then just now, about 15 minutes ago, you heard the lead prosecutor, who's from the AG's office from Austin, Texas, has no dog in this fight, testify that this was a just prosecution and that they had nothing to seek except justice. The court in Muniz and the dissent in Locke said that we should hold attorneys to a higher standard. We absolutely should. The practice of law is a privilege, not a right. By being convicted of 9 counts of felony crimes of moral turpitude, which are serious and intentional crimes, respondent should lose that privilege. You've heard testimony from respondent's friends about her character, about how she's a good mother, I think someone testified to. That may be, but that does not mean that she should be able to keep her law license. We'd ask the board to keep in mind that we are charged with policing our own. To allow her to keep her law license, as part of the charge with policing our own, we're called upon to make sure that we uphold the integrity of our profession. To allow her to keep her law license would undermine that integrity and would erode the public's confidence in our profession. I'd ask you to keep in mind that the convictions for these crimes were in furtherance of the respondent's campaign to become a judge, and that damages our court system. Looking to the pertinent aggravating factors set out in the Filipov opinion is 1, this was directly related to her practice of law. 2, you've heard numerous times, respondent refuses to accept responsibility for these crimes.
Ms. Stevens, may I interrupt you for a moment?
Please do.
This was the part dealing with the campaign finance documents, the incorrect documents were filed as far as campaign finance. My understanding is that to be a district judge, one cannot practice law at the same time. I think somebody can correct me if I'm wrong, but I think that's right. To the extent we're talking about campaign finance documents, how would that be a direct impact on the practice of law if in filing those, you actually can't practice? You see where I'm going?
I do. Well, she was a practicing attorney up until the time she became a judge. This all happened during the run-up to the election. This was not post-judgeship. These things happened as a practicing attorney. She was a practicing attorney running for judge. She could not have run for judge for district court if she had not been a practicing attorney. And that's our direct connection.
I think that's a fair, I understand your point. What I'm wondering about is that it has to be directly impact a law practice, but it's almost ipso facto that it can't directly impact a law practice, can it, if it's for judgeship?
Well, I think that the opinion says directly related to the practice of law, and the way I've explained it is how we think it is directly related to the practice of law.
I understand your answer. Thank you.
Thank you. Good. A second factor that's laid out in Filipov is credibility under oath. And I would submit to you that her credibility under oath is questionable. She acknowledged her guilt under oath at her punishment hearing to avoid prison time. And then here, under oath, she refuses to acknowledge her guilt in an attempt to keep her law license. For these reasons, the aggravating factors set out in Filipov, and our duty to protect the integrity of our profession, For all these reasons, these convictions demand disbarment. I think suspension would be an injustice to our profession and the public. The Commission for Lawyer Discipline respectfully requests that the Board of Disciplinary Appeals disbar Suzanne Wooten. Are there any questions?
I have one. When, in the commission's opinion, would it be suitable to suspend? Because my understanding, being on this board for the time I've been here, is that it is general policy that in these compulsories, you always seek disbarment. Can you think of an example to help us as when you would ever think suspension would be appropriate in a compulsory?
Well, as the board is probably aware, I haven't been at the Chief Disciplinary Counsel's office almost 2 years now. I suppose that we might entertain a possible suspension or agreed suspension on maybe a drug charge or something that doesn't affect the practice of law, and that the public and the profession itself wouldn't look at and say, how can you not disbar someone for this? I think those sort of factors would come into play when the commission and the Chief Disciplinary Counsel's office looks at the crime and decides whether to pursue disbarment or suspension.
And how long have you been with the office?
Almost 2 years.
2 years. In the 2 years that you have been with the commission, do you know of any instance, drug-related or otherwise, that a compulsory was brought to this board that the commission did not ask for complete disbarment?
I'm not aware of any. The ones that I've brought before the board, the respondent actually served prison time, so the question was moot.
In the Pope case, which you mentioned a couple of times today, the conviction was possession of child pornography, was it not?
I believe that's right.
And this board did choose to suspend that attorney. I wonder, do you have any thoughts on what guidance, if any, that gives us compared to the offense we're dealing with here? And perhaps they aren't.
You mean the Pope case in general? Or?
Well, that type of, is that an offense which is more appropriate or less appropriate, or do you have a view as whether that would be a time in which this board should exercise its discretion and suspend?
I see. Actually, I would stand by the argument that was made before the board, as I understand it was made before the board at that time, that he should have been disbarred.
That is the argument your office.
And I would agree with that.
Okay. Let me ask you something, one other thing while I've got the floor on kind of a different subject. Is there really any functional difference to the effect on the respondent between a disbarment and a 10-year suspension under these circumstances? She testified. She's 44 years old. The case has gotten lots of publicity. It's not immediately clear to me whether the difference between the practical difference between disbarment and a 10-year suspension in this particular case is that significant. But I'm interested in your views on that.
I would say that attorneys practice well into their 80s and 90s. I know a few. And so that's 44, 10, 15, she's 60, still got a good 20 years there, maybe 30.
I think their argument is kind of she's been punished an awful lot already. And even if we were to exercise our discretion, that's still a pretty serious sanction.
It is a serious sanction, and we think it's appropriate in this case. The criminal punishment is separate and apart from this punishment. This punishment is, to some extent, dictated by that, but I don't think that the board should say she's been punished enough because she's on probation. Again, I'll go back to the public's confidence in our profession and our integrity, and these crimes call for disbarment. I think you said, what's the difference between the suspension and disbarment? I mean, in reality, what's that doing? Under the rules, she would have to retake the bar exam. She'd have to go through a reinstatement hearing and have a judge say that she could retake the bar exam and go through that whole thing. And we think that that those requirements and having her go through those things were she disbarred is a good thing in this case and should be required by this board.
Other questions? Thank you.
Thank you. May it please the board, honorable members. First of all, I do want to apologize for my last witness. I'm very passionate about this particular case, so I know I've got long-winded a little bit. You kind of figure out how difficult it is to get the information out from certain witnesses who are very adversarial to your position. So I apologize for that. I hope that you don't hold that against Judge Wooten. Why are we here? As you all know, being members of this board, a lot of attorneys just don't bother to show up. They ignore it. They ignore this process. I think Mr. Lee is very well aware, and the other panelists that have reviewed motions that have been filed in this proceeding. I mean, heck, we're here on a special setting for the last 5 hours, that we have taken this very seriously. And we believe that you all, with your discretion, have the absolute obligation to look at every case differently and to look at the underlying facts that got us here. Ms. Sheridan, that was a good point. I entered into discussions with the board or the bar early on about talking to them about doing an agreed sentence, and my response was, our policy is we always seek disbarment. And so we'll see at the hearing kind of thing, so this is where we are. What have we learned through the witnesses that we've put on? As many of you know, these were not just lawyers from North Texas. These were distinguished lawyers from North Texas who have been practicing many years, former judges, members of the Bar Association, presidents of Bar Association sections that know a lot of the lawyers in the area. And all of them have a consensus. But this was a witch hunt. This was a political prosecution. Yeah, they got their conviction, and that's why we're here, all right? Because if they didn't have their conviction, we wouldn't be standing before you. But what was the two important things that this board heard, not only from Judge Wooten herself, and by the way, I use the term Judge Wooten as a term of respect, and I know she's no longer a judge, but I owe that respect to her because I believe she's innocent of these charges. And that's very difficult for me to say. I used to be a police officer. There's two things that happened here from Judge Wooten herself. She was offered a Class A misdemeanor to just go away. Judge Sandoval, who was a tyrant in Collin County, was upset because he got beat by a 60-40 margin on election day. His response was to go to his buddy, the DA at the time, and say, launch an investigation. I don't care what it is, you just got to find something. We heard that from Mr. White. He wouldn't commit to it, but what we did find is the grand jury subpoenas that went out had election fraud. Then we kind of go into this 6 grand juries later, she gets indicted. And then we talk about the bribery statute. I'm going to harp on this, and I want you all to really look at the bribery statute when it 3602 A1 and A4. Harry White, who was the lead prosecutor on this case, what did he talk about? Campaign contributions. Then he wanted to say, well, there had to be legal campaign contributions, they weren't reported. Well, she didn't receive any money. Their allegation, the underlying offenses was that her campaign manager got money from a third party, made expenses, billed her, and then she turned around and paid it. She never came out ahead. She paid every campaign expense related to these allegations. And Mr. White says, no, we're not going to go under A4 because they've got to be legal. Well, no, Mr. White, you didn't go under A4 because you've got to have direct evidence of an express agreement. That is, you got to have a wiretap in the back of a church saying, you're a judge, I'm going to give you cash, and you're going to give me this in turn. It increases the burden on the state. So what do they want to do? To pressure her to resign? We're going to indict her under A1 because she was bribed to run. How do you bribe a private citizen to run for judge? You're going to go bribe every citizen that votes in the county? It doesn't make sense. And I want the board to look at that and understand that the reason they made that decision to charge under that section is because it decreased their burden. I understand that having a law license is a privilege and not a right. I'm standing here before you as somebody who did not grow up with a lot, that was able to earn a law license and be able to practice in this state and before this board. The same as Judge Wooten. You've heard the evidence. She's never been convicted of any other crime. She's never been grieved. She's never been disciplined. This is a model citizen except for the 9 felony counts that we believe were fraudulently got against her in Collin County. Let's talk about the offers. Mr. White was evasive with you. Mr. White said we didn't offer any other offers to anybody else. But when I got him back on cross-examination, what did he say? No, we did offer Stacey Carey full immunity, that she would roll on the other co-defendants. That should resonate with this board. I know many of you are not criminal practitioners, but if somebody was guilty of what they're accusing of and they have an opportunity to walk with nothing, to just testify against the other co-defendants, they're going to take it. And they didn't. Now she finds herself convicted. Same thing with Judge Wooten. She had an opportunity to take a Class A misdemeanor to get the goal of what did the Attorney General state they wanted? All they wanted was for her to get off the bench. That's it. Mr. White sits here and tells you he didn't want her to have prison time. He didn't want her to go to jail. All they wanted her was to get off the bench. Well, she is. If that's good enough for them, it should be good enough for this board. That she's going to spend the next 10 years not practicing law. And I agree with you, Mr. Williams, that 10 years is a long time. But the process after somebody serves out their probation, if they're disbarred, to be able to reapply is not guaranteed. They have to go through the process, and they have to retake the bar exam. I know everybody on this board probably only took it once, and God forbid, don't want to have to take it again.
You have 2 minutes.
Okay. So I find the very compelling argument by the state that she acknowledged her guilt in the hearing, but then wouldn't do it here. That's not compelling to me because that's what you all want. This board wants somebody facing sanction under this board to come in and say, I did it. Please have mercy on me. It's against her interest for her to come in here and state that she didn't plead guilty, because that goes against what this board is expecting. I know this is different. I know this is not a situation where most people come in here and they lay down and they say, I'm sorry, I did it. I took $170,000. I'm paying it back. I did a bad thing. Nothing that you heard from the evidence today shows that that's what this respondent did. She deserves to have a law license. She was told by members of the community that she's a good lawyer. She was, I hate to use the term, raped by the Collin County judicial system. And that is my belief, and that is the belief of many of the lawyers in North Texas. And she is here to fight for that. 10 years probation. She can't leave the county. Every time she wants to go travel, she's got to get a travel permit for the next 10 years. She's got to pee in a cup with a woman watching her every time she appears for probation. This is not a slap on the wrist, as the state bar wants you to say. She was given 10 years probation, not prison time, because it was the right thing to do. And because the state agreed to that, and because she has a fully probated sentence, is why we're here. You have the discretion under the rules. And I believe that with all the evidence that you heard, some of it you didn't want to hear, I understand that, but we wanted to put out as much in front of you as you could to understand how we got here. And we plead today, stop the travesty, stop the injustice, and just suspend Judge Wooten for 10 years. That's what we're asking for. Thank you.
Anybody have any questions?
Mr. Kidd.
I have one question. I want you to set aside all of the rhetoric, if that's the right term, about Collin County, injustice, she was raped, all those things. I want you to set that aside, and I want you to tell me every reason in your mind, setting aside the injustice, and because she was found guilty. I wasn't there, but she was found guilty, and I want you to tell me every reason why we should suspend her. I want to hear about Collin County again.
Mr. Kidder, I'm not going to go there. I'm going to tell you, this is the most honest woman that I have ever met in my life. She had the opportunity to get out of this multiple times, but she believed in the integrity of our justice system. Maybe that was good belief or not, but she would not take a plea deal on this, even by pushing by me, because she says, I cannot accept a plea deal for something I didn't do. And that should have great weight with you all, because most people, if they did something wrong and they get to keep their ticket, as Mr. Corbett talked about, they're not going to risk having to come before this board. She's a great mother. She's an honest lawyer. She has integrity. Now, and you're not going to see the kind of support. If people actually believe that these are the things that were true, with the convictions, we would be standing here by ourselves. I don't know if we would even show up, because that's what people who are guilty, that's what people that do these things, they do. They don't participate. And we have, and those are the reasons why you should suspend her. She is a good asset to this community. And the people respect her and they like her. And I appreciate you asking me that question.
Other questions? Yes, Skarwitz?
Irrespective of what you suggest the motive may be for the indictment and the prosecution, a jury did find her guilty. And I recall, and you're trying to convince us she really wasn't guilty, that the jury was wrong. And your statement was the only reason the jury convicted her was because she was indicted. And I ask you, is that the only reason she was convicted? And you said yes. And I ask you, how do you know? And you said, because the jury told me so. And then when the Mr. White disputed that, you said, no, I didn't say the whole jury, I just said one.
The jury was together. We were talking.
I mean, that was what you said.
And I
And
may
when
have
she asked you
misunderstood.
to name a juror, you said, I don't want to be cross-examined, I don't want to be put under oath, and yet you asked him what lawyers told you that they agreed with the judgment, with the verdict. So I don't know where we're going with this semantic game.
I'm not going with the semantic game. What I said is in the jury room where Mr. White was present, there was a juror in there that stated they wouldn't have indicted her unless she was good for it.
That's not what you said. You said the only reason she was convicted was because she was indicted.
That was my belief.
But that's not what you said.
Well-
You said the jury. So you're saying now the jury didn't say that.
No, the jury said it. The jury absolutely made that comment to me. Also, that she didn't ask enough questions. Those were conversations had with jurors. I took that to believe that the only reason she was found guilty was because the DA indicted her. The classic common.
That's your
common
belief. That's
Yes,
not what the
absolutely.
jury said.
Yes. No, the jury did state that.
Am I going around in a circle?
Yeah.
Am I? You said
I-
one juror said it, not the jury.
They said in deliberations.
They,
we
wait a minute,
discussed-
they, how many said that?
All 12 of them were there. The one juror who was one of the I don't want to call it the foreperson, because I don't know if it was the foreperson, said that we discussed it, that the DA hadn't indicted her, or that because the DA indicted her, that was one of the reasons we found her guilty. That was said in the jury room. And Mr. White now says he doesn't recall. He didn't dispute it, he just didn't recall.
And he also disputed that was that was the reason that they found her guilty. And let me ask you one other thing, and I'm not trying to argue with you, I'm just trying to understand what you're saying. You're saying that she understood when she got up there and elocuted that she really wasn't pleading guilty, that the document you introduced that said that required her to plead guilty to what the jury found her guilty of, and that was the condition that the court would approve the plea, that when she got up there, she really wasn't doing that. She was not really pleading guilty like the judge said she had to, but only she was agreeing that the jury found her guilty. Is that what you're saying?
Based
So
on the email, go ahead.
Look at the judge, is that what?
I disagree with that. I
Asking.
This is not, let me step back I'm a criminal practitioner, so let me talk about pleas briefly. Plea bargains, when somebody enters a plea, okay, all their admonishments are read to them like we heard evidence of. You gotta waive your right to, appeal, all this. That did not happen in this case, so this was not a plea. That's what I'm trying to say, is this was not a plea.
The requirement of the judge is, I understood the document you introduced was she had to plead guilty to the things that the jury found her guilty of.
Mr. Gervais, can I show you the document?
Oh, no, am I wrong about that?
Yeah, you are. You're misstating what.
Look at the document.
Okay, I'm sorry. I'm not trying to argue with you.
No, that's fine.
I just disagree with what the document states.
Other questions? Yes.
I understand you've got a little bit of a challenge in that you've got basically a situation where your client says she didn't do what was underlying. As I read the factors in Pope, which is not an exclusive list, I think somebody along the way today said that it was an exclusive list, it's not. What comes through is the element of contrition, that there needs to be something in there where there's an acknowledgement that somewhere the wheels got off the wagon and an acceptance of responsibility. That's expressly there, but it's also there in a couple other ways. And I want to hear from you what your best acceptance of responsibility is. Because what I hear you saying is she's saying to this day that she didn't do it and she just did it, she just tried to get out of it so that she wouldn't end up in jail, so that her kids would have a mother to come home to, and just to avoid that kind of responsibility. What's the best evidence in the record before us that she has accepted responsibility and been the slightest bit contrite about what has happened here?
I will tell you, let me answer that in two parts. Okay, the first,
Question?
Yes, sir.
So that you can answer 3 parts?
sure, let me write this down.
This is simple. This is simple. I want you to, in answering his question, also argue for me for an extension of the factors in the Pope case so that you don't necessarily have to, quote, accept responsibility for past conduct.
I've read the Pope case, and I understand the factors, and I will be honest with you, walking into this board, I had absolutely no hope walking into this chamber today that I was going to get my client suspended for 10 years because of Pope. And then when I started going through the evidence and started seeing how it was playing out and the questions that this board was asking, that became my opportunity, was to argue, well, could this be an extension of the Pope case? What I will tell you, is it Chalmette?
That's me.
Am I pronouncing it correctly? Mr. Chalmette, when you ask about contrition is, she knows she waived her right to appeal. She knows that. And what has she done? She doesn't have to accept responsibility by saying, yeah, I did this, but what has she done? She's finished everything on her probation. She's attended every probation meeting. She's done every class. She's done 1,080 plus community service hours. So if there's any sense of contrition that she's accepted responsibility, is she's moving forward with the consequences of her decisions. And I think that needs to resonate with the board. Under the Pope case, Mr. Jones, this case does not fit into the Pope case. I mean, this case is very distinguishable from that particular case. And I understand why the factors are there, so there can be kind of a streamlined process of what the board looks at. But this is an extraordinary case. With the politics that were involved, with everything that happened here, with the facts that are for this board, is you have a woman that claims that she's innocent. And we had that happen in our criminal justice system before. People have been convicted of crimes, gone up on appeal, they withstood appeal, and 15 years later, Dallas County, 22 people have been exonerated, 22 plus, because of that. So those happen. I'm not saying that you guys need to take the leap of faith. I'm not asking you to say in this particular board, because we're not going to relitigate, even though we appear to have been doing this entire time, we're not going to relitigate the underlying criminal cases. I'm not asking you to say we find her not guilty. What I'm asking her to do is to look at all the factors, look at how she lived her life, look at how the case came about, look at how she maintained her innocence, look at how the other co-defendants have maintained their innocence, but she's accepted the system's consequences by doing what she's been asked to do. And that would be my only evidence of contrition, that she's accepted responsibility. I mean, this is not, like I told you from the beginning of my closing argument, Mr. Chairman, this is not a case where you have a defendant or a respondent that's going to stand up and beg for mercy. I've changed my ways. I'm sorry that I stole that client's money, that sort of thing, because that's not the type of case you're dealing with. It's different from Pope.
Other questions? Thank you.
Thank you. I do appreciate the time.
Stevens.
Members of the board, just to clear up a few things, I was told by co-counsel that there have been a couple of cases in previous years where we submitted a proposed agreed judgment for less than disbarment, just so that's out there for the board.
It has happened.
It has happened. And kind of in that same vein, the case law says that we start at disbarment. It's not respondent's burden to mitigate down from that. So I don't think it's inappropriate for us to come in here and ask for disbarment, because that's where you start. Respondent's counsel said that this is an extraordinary case, that you kind of have to go into the underlying facts. The point of compulsory discipline is not to go into the underlying facts. You get convicted, you come here. This isn't a regular evidentiary case where you get to relitigate everything and go into all of the facts. We'd ask the board to keep that in mind and to not consider a lot of irrelevant evidence that was put on today. You heard a lot of, I'll call it argument from Mr. Schulte about what the juror said, what Mr. White said, but as Mr. Gerwitz pointed out, there's been no testimony by someone under oath as to those things. Mr. White said that he didn't hear any jurors say that. Mr. Schulte's backtracked off of the entire jury saying that to now it's one jury. But again, you've heard no one under oath testify to that. Also, he said that all the AG's office was looking for was to get her off the bench. I think Mr. White emphasized that was one of the main concerns, but that's not all they wanted. You heard him testify that he thought she would be automatically disbarred with these convictions, even though she was given probation.
Can I ask a question? Taking their set of facts as being true, this seems very Kafkaesque. I mean, basically, you've got somebody who is convicted of something that they didn't really do. And what do you do when that happens? How do you object? How do you show the contrition that I was just asking about? I'm asking the flip of what I just asked your opposing counsel. How do I stand before you and show contrition when I didn't do it?
You appeal your conviction.
Let me add to his question, if I may.
And take your hand out of my back.
By simply asking the same question that I asked for counsel, which is, are the factors in Pope exclusive factors?
I'll address yours first, if I may, Mr. Jones. I don't think that they are exclusive factors. That I think the opinion states that we may consider such factors as. So there is room for other factors there. Mr. Chalmette, you appeal your conviction.
But so in other words, you bite the bullet and potentially spend years in jail for the sake of protecting your law license once you get out. I mean, that seems to be a tough pill to swallow. I'm glad I don't have to make that decision.
Well, I think she testified she didn't agree to the probation because of her law license. She agreed to the probation for various reasons, including her children being home for dinner, things like that.
But you would agree that sometimes in criminal cases, people make choices. They compromise, to use a word that's probably not used enough these days. And they make decisions that they probably wouldn't have if they were to suffer no ill effects if they didn't make that decision.
I do agree with that, and I would point back to something the board heard at the very beginning of this entire hearing. Mr. Schulte read into the record Judge Rush's testimony at a deposition, and he said, I understand that, but you don't get to keep your law license. You don't get to stand in front of this board and ask them to allow you to keep your law license, and that's our position as well.
Ms. Stevens, I'm sorry, I didn't mean to interrupt you. Let's take the hypothetical that there is an innocent, there's just a wrong conviction. Are you saying that is it your argument that the only way this board should look for a sanction less than disbarment is if they win an appeal?
I'm sorry.
Is it your argument that if a person is actually innocent, taking a hypothetical, taking it out of this case for a moment, that because of the conviction and we don't look at the underlying facts to re-argue guilt or innocence, that the only way that a person or the board should consider a lesser sanction, probation, a suspension, is if they went on appeal. So they get probation and they appeal it. Do they have to win the appeal before we should consider?
Well, I wanted to put the exact question, but put a spin on it if they lose the appeal.
Yeah.
In other words, you seem to be saying she waived her right to come in and ask for anything less than disbarment by waiving her right to an appeal. So let's say she hadn't done that. Let's say she went forward with her appeal, as you said is the only way, in answer to Mr. Chalmette's question, to contest that conviction. What if she lost it? Could she still come in and also, I don't want to butt in on your question, but he says, what if she wanted? Is that the only way then that we could give her less? And then what I'd like to know is, what if she lost it?
Okay, I will try to address all of that. It's the commission's position that the penal system addresses innocence versus guilt, and that's where that should stay. The rules specifically say that a conviction is conclusive evidence of an attorney's guilt if they are convicted. They also say that you're not allowed to collaterally attack those convictions. So yes, I would say she is not allowed to come in
Then
here.
what's the point of our discretion?
I'm glad you asked. The factors laid out in Pope, Philippov and then Pope, don't talk about, I mean, not all of them talk about innocence versus guilt. I mean, you've got factors, has she completed her probation, things like that. I'll read out the factors for the board. Whether the crime is directly related to the practice of law, whether she appeals the conviction or doesn't, that you can make that decision on its face. The conduct of the attorney during the disciplinary proceeding, excuse me.
Talk a little bit slower.
Thank you. The conduct of the attorney during the compulsory proceeding. Whether the attorney has complied with the terms and conditions of probation. The attorney's efforts at rehabilitation. Attorney's credibility under oath. Whether the attorney accepts responsibility for past conduct, and any prior discipline imposed on the attorney. And again, those aren't the only factors that the board could take into consideration.
And Ms. Stevens, aren't you reading from Pope?
I am.
And just directly above that list, doesn't the board say that we can look at underlying facts in mitigation?
It says we may consider evidence of the underlying facts in mitigation or aggravation of the sanction to be imposed.
So isn't the tension we have? Are we looking at facts, the underlying facts for mitigation of a sanction? Do you agree we can do that?
I agree that that's what the Pope opinion says. Yes.
Okay, and I appreciate that information. Is it your position while you're arguing to us that that's incorrect? And it was also says the same thing in Philippov, because it actually cites from Philippov.
The factors are from Philippov. This part where it says we may consider evidence of the underlying facts in mitigation or aggravation, I think that part is not directly quoted from Philippov. I just make that
It's pretty
distinction.
close, though.
Is the argument that if the lawyer stole the money because his kids were starving, that we couldn't go behind that he stole the money, but that we might be able to suspend him because of the reason he stole the money?
Yeah, I think that's what the
And
board.
is that what you're arguing? Not that she wasn't found guilty, but that it was a trumped up charge, they never should have charged her in the first place, so is that what you're arguing? Yeah.
I was making, it's a little bit of both. I'm distinguishing, and I'm not going to get into her time. I'm
You're not
distinguishing.
saying she was found guilty, can't get around that.
Correct.
But you're saying, but mitigate it because she never should have been charged, even though she actually was found guilty.
It's also
Is that a
the nature of the crime, Mr. Gurwitz. Basically, bribery in this particular case had to deal with campaign finance.
Yeah.
Money she never received. It wasn't money behind the back of a
I
church.
don't want to get into any of that. I want to understand how we go beyond, without getting into the fact that she was convicted. I don't care, you say they convicted her just because she was indicted. I mean, we can't go anywhere with that. When I was trying lawsuits in the third quarter of the last century, you couldn't indict. I mean, you couldn't set aside a jury verdict by the juror's testimony that they didn't mean it or whatever it was. We're not going to get anywhere with that. I'm just trying to understand your argument, how you're not asking us to set aside the jury verdict.
If in this particular case, Judge Wooten was convicted of accepting a bribe under the statute that's appropriate, direct evidence of express agreement in exchange for favorable rulings, I would not be here making the argument that I'm making. Okay? That's what I want the mitigating factors that a pope allows. That's what I'm asking this board to consider behind the convictions. This is not bribery. You say bribery, everybody thinks it's what it sounds like.
She was convicted of the wrong crime, is that what you're saying?
She was convicted of the right statute under the wrong parameter. If you want to say she was convicted, we still maintain she didn't do it, but I'm not making that argument to this board.
Well, she was convicted. I'm not saying she admitted it, although.
I just asked Mr. Gurwitz, you look at 3602A1 and A4 and make the determination. The A1's a lot easier to be trumped up by a prosecution.
So you're asking us to set it aside on a legal,
No,
on a point of law?
I'm not asking you to set aside the jury's verdict. I'm asking you to take it into consideration. about how we got here. Look behind the convictions to use your discretion. That's what I'm asking.
Ms. Stevens?
If I can go back to Mr. Cruz and Mr. Gerwitz's question, Mr. Gerwitz's example of stealing the money to feed your starving children, those are the sort of mitigating evidence of the underlying crime that I think the board was talking about in Pope. All of this mitigating evidence that you've heard is an attack on the underlying conviction. It's not appropriate. And I hope that answered y'all's question.
But yeah, I don't think you answered Ms. Race's question, because at the end of the day, I think of this in terms of two buckets, if you will, two states of the universe. One in which Judge Wooten is the evil incarnate, and she meant it, and she's lying to us, and she's a horrible person, okay? And there's another one where she should be suspended because of some other reasons. And I don't know which one she fits into, but I know what the facts are generally. What does it look like if she deserves a suspension? What sort of facts should she have said, should she have brought forth? Appealing the conviction, my experience has been that when you have a case where someone is continually appealing the conviction, we get to this attorneys accepting the responsibility issue. And then they don't accept the responsibility because they're continuing to fight against the process. They're not accepting the responsibility. So it's a little damned if you do, damned if you don't. So I'm really struggling with how, even under our own precedent, in this type of unusual fact circumstance, someone can show that they deserve suspension given their numerous protestations that they didn't do it. And what would they have to do to show that? I don't know what we should be looking for. I'd like to hear that from you.
Well, first of all, I would say that that's not the only factor laid out, and it simply...
I'll give you that.
Okay. I think you don't get into the other bucket in this case. I don't think you get into the suspension bucket. I don't think there's any facts that can be put on that gets you into the suspension bucket.
So you're saying she can't get in that bucket even if she had appealed? I mean, I think you've pointed out the
Are you saying
dilemma.
she can't or she didn't?
Did not.
Because there's a
Sorry,
distinction.
can't at this point get into that.
But let's,
But I was asking, how could she? And
Right,
what
that's
you're
my
asking.
question.
How could she, put aside today, how could she, if what you've told us a few minutes ago is, your answer earlier was she would have had to have appealed. So that's where I'm going. Let's put today aside and say, okay, we're here, she did appeal, she's made all this, the same testimony. Could she then get in that bucket?
If you heard the same testimony that was presented today, she lost on appeal. No, I do not think you get to attack the underlying convictions then, even if she maintains her innocence at that point.
So then in your position under our statute and our, what we're looking at to make this determination, the discretion really isn't gonna enter into it under this scenario, because under your position, she was found guilty, and so we can't go behind it in any sense.
No, I don't think that's my argument. The board has the discretion. She was given probation.
But
You
when, I
have the
guess what
discretion.
Mr. Chalmette was asking is, when would we ever use it under these facts? I mean, when, you seem to be saying we don't have any right to use it. She waived her right to appeal, and somehow that equals waiving her right to get suspension here. So that's what I'm struggling with too.
The reason that I emphasize she waived her right to appeal on these convictions is because we've heard so much evidence attacking these underlying convictions.
5 minutes left.
Can I get a little longer since I cut down from 30 from my hour?
I think we have to
Absolutely,
leave.
but we're running out of
Oh,
court
we're
time,
close to
so,
5. I apologize.
you know, let's let her, yeah.
5 minutes is the court deadline.
Give her a chance. Yeah, you have plenty of time.
That's why.
It's not an equitable argument, it's an argument that you ought to set aside the judgment because they indicted her on the wrong grounds. It's not an equitable argument, it's a legal argument. And I think your position is the only place you can present the legal argument is on appeal. The equitable argument comes to us, where is the equitable argument?
Yeah, let's hear from this. I think she wants to make some concluding statements, and then we'll go into our own discussions.
I do, and I don't mean to imply that the board doesn't have discretion here. I just emphasize that all of the testimony attacking these convictions is not relevant. Under our rules, it's conclusive evidence of guilt to have those convictions. That's why I keep emphasizing that. I'd like to point out to the board that if the respondent had not testified the way she did under oath in the punishment hearing, we probably wouldn't be here. She would have gone to the jury for punishment, and it plays out that way. And it sounds to me like everyone thinks she would have been sentenced to prison time. That's the argument that I've heard. So going to the punishment hearing and saying, I acknowledge my guilt, and then coming here and saying, I don't, and respondent's counsel has said, well, it's not in her interest to not acknowledge her guilt. Well, it is. That's their whole position. The whole thing is an attack on the underlying convictions. And lastly, I just ask the board to please keep in mind that we're here to protect the public and to protect the integrity of our profession, and ask you to disbar the respondent.
Thank you.
Any other questions?
Thank both counsel and the witnesses. We appreciate your time.
Especially the witnesses that have come so far.
Yes. Take it under deliberation by counsel.